Hi, I would like to go through how to answer a voluntary manslaughter AO2 scenario question for OCR Law. I've done previous videos which explain the AO1 knowledge and understanding elements of these topics, so I'm not going to go into a whole lot of depth for those. I'm also going to split this video into two parts, so you'll need to watch the second part to learn more about the defence of loss of control. So, as a reminder, what is the task that you'll have to do in the exam? You'll be faced, if it's an AO2 question, with a scenario that is worth 25 marks and you have 30 minutes to achieve those marks. The assessment objectives are set into two, and you can see here that I've colour-coded them. 10 of the marks available are for your AO1 knowledge and understanding, so your ability to explain voluntary manslaughter with case examples. And then AO2, which is out of 15 marks. And your AO2 is your ability to take that knowledge and apply it to a given scenario. So the first thing you need to check is what you're actually required to talk about in the scenario. A scenario question for voluntary manslaughter can have a few variations when it comes to the command line of the question. So read it carefully. What is it actually asking you to consider? Is it a murder question? Is it murder and involuntary manslaughter? Or is it purely voluntary manslaughter? So that's the first thing that you would need to check. Let's assume here that the question is not about murder, it's just about voluntary manslaughter. And it's about the two different types, diminished responsibility and loss of control. So how would we go through and answer such a question? What I've done here is I've tried to thread the AO1 and the AO2 together. Now, you don't have to do it that way. If you're not very confident with voluntary manslaughter, you can do all of the AO1 first, which is represented here in green and orange, and then the AO2 later, which is represented in the pink. You can also put headings, which I think is a really useful thing to do. So, how do we start our answer to a scenario? First thing you need to do is start with a definition. I always think simple is best. So quite simply, voluntary manslaughter is. And remember, voluntary manslaughter is where the defendant has committed murder. They have the actus reus and the mens rea, so they've caused an unlawful killing of a human being under the Queen's peace, and they had malice aforethought. But their argument is that they did that because of a special reason, either because they have a recognised medical condition, which meant that they were unable to control themselves or judge what they did, and that's why they killed, or it's loss of control. It was something the victim did that provoked them into acting. So you might also want to talk about the sentence for voluntary manslaughter, which is maximum discretionary life. Remember, murder is the only crime where it is mandatory, murder and mandatory. Voluntary manslaughter has a sentence of maximum life, and it can be anything up to that. And remember, for things like diminished responsibility, things like hospital orders might be relevant. So next thing to do in the exam is to actually thoroughly, of course, read through the scenario and look for hints that could involve either diminished responsibility or loss of control, or both. So roughly speaking, diminished responsibility, we are looking at internal causes, medical conditions. Whereas loss of control is externally caused. There was something that someone else did which acted as a trigger for you to lose control and kill. So we are looking for elements of a condition and elements of the victim bringing it on themselves. So once we've found that, we've gone through, we've highlighted the scenario, and we are confident that we have some evidence, we're going to start applying it. Let's start with diminished responsibility. So diminished responsibility was originally covered in the Homicide Act, but is now importantly been updated in the Coroners and Justice Act 2009, and you need to be putting in the most recent law. Now, the law just tweaked a few of the things in diminished responsibility. It updated some of the wording, for example, to make it more clinical. But we do need to be talking about the current law. And cases from before 2009 are fine to use for diminished responsibility. So let's start going through. The real key, especially if you're blending your assessment objectives together, is to make clear to the examiner that they are distinct from each other. How do you do that? My suggestion is for each point you want to make, you need 2 very clear sentences. The first sentence is completely and utterly objective, with no mention or reference to what's going on in the scenario. The first thing, for example, for a claim of diminished responsibility is that the defendant must have an abnormality of mental functioning. This means, according to the Byrne test, that their thinking and reasoning was so different from a normal person that a normal person would judge it as abnormal, which is of course a job for the jury to decide. Full stop. All of what I've just said there is A01 because I haven't made reference to any scenario or any particular person. And what that means is the sentences are green and the cases in orange, you can recycle. So any question on diminished responsibility should have the green in there. Memorize that. Then what I'm going to do is apply it. And a good reason for doing it in this blended approach is because sometimes there is some overlap between the 2 types of voluntary manslaughter, and people can get really confused if they try and tackle them at the same time. So I think if you go through some AO1 and then go straight into the AO2, you're much more likely to have that separation in your marks and in your credit. So the question, of course, is whether actually now the person in the scenario did have different thinking to an ordinary reasonable person. Generally speaking, of course, if they've attacked and killed, they probably do. Maybe have a look out for any signs that the person in the scenario is on medication. Why is a person on medication? Because we're trying to correct a type of mental functioning that ordinary people don't have. The next thing is that the defendant must have a recognised medical condition. We're back to AO1, so we're back to using neutral language, not referring to anyone in the scenario. You may want to give some examples of commonly recognised medical conditions, things like depression, schizophrenia, PTSD. Then we switch to our AO2, and again you're looking for signs in the scenario that this person has a recognised medical condition. So it could be that you're very, very lucky and the scenario tells you Dwayne has depression, for example. Has someone been suffering with something? Has someone been diagnosed with something? Or is it just hinted at? Does a person take medication for something but they haven't outright said this person has depression? Do they suffer from things like panic attacks or delusions or visions, or do they hear voices? Even if they haven't been to the doctors and have a diagnosed medical condition, it could be that they clearly have signs of a recognised medical condition. So if it's telling you that a person is hearing voices and suffering from delusions, the scenario may not go as far as telling you they have schizophrenia, but that's clearly the direction the examiner is taking you to. Now, be careful if the scenario starts mentioning alcohol. I'm going to talk about that at the end of the scenario. It may not, it may stay away from intoxication, but just bear that in mind. We'll come back to that in a moment. The next thing is that recognised medical condition must lead to the defendant's abilities to do at least one of 3 things to be substantially impaired. And the case of R versus Golds recently in the Supreme Court told us that substantial has a commonly understood meaning for jurors to rely on. So it's not total, but it's not trivial either. So the jury would have to decide if it was a substantial impairment or just a minor impairment. So essentially it has to impact on the defendant's ability to either understand the nature of their conduct, form a rational judgment, or exercise self-control. That's where that overlap comes in I was talking about earlier with loss of control. So in both, essentially what we're saying is the defendant lost control, because of course if they were able to control themselves, we expect them not to kill. But in both types of manslaughter, we are saying the person was unable to control themselves because. And here we're saying they're unable to control themselves or understand what they were doing or make decisions properly because of an internal recognised medical condition. So what sort of things are we looking for in the scenario? So let's now turn to our AO2. So is there any signs that maybe they didn't understand what they were doing? So perhaps they were having delusions. Perhaps they were daydreaming. Perhaps they have post-traumatic stress disorder and they thought a person approaching them was actually an enemy soldier. Or maybe they have paranoid schizophrenia and they think the person coming towards them is the devil or aliens attacking. Or has a person maybe blacked out and they were unconscious and they sort of didn't really realise what they were doing? That they were unable to form a rational judgment. So essentially what we're looking for here is that they're not thinking straight. Was there elements that they were confused? Again, blacked out. If there's any evidence of planning, of thought process behind this, of waiting and springing later, that probably suggests that they were able to form a rational judgment. And lastly, that they couldn't control themselves. So we're looking for elements of that they just couldn't stop themselves. They lost their temper, they saw red, they blacked out, they acted without thinking. Those are potential signs that the person didn't exercise self-control. Now remember, in the scenario, for this defence to succeed, you only need one of those three things. There may be more than one. That just strengthens the argument that they had diminished responsibility, but you only need one to be able to proceed. Those are the three main steps that you need to decide and explain. You would only talk about intoxication if it's relevant. So if there is any signs, any reference to drink or drugs in the scenario question, you should then be considering intoxication and the relationship between diminished responsibility. So just like before, in green, we have the AO1 rules. There are three main rules when it comes to intoxication and diminished responsibility. And then you work through them to see if any of those apply to the defendant. The first thing to really make clear is that alcohol or drugs cannot be diminished responsibility alone because they don't stem from a recognised medical condition. So although if a person is very, very drunk, clearly their responsibility is going to be lowered, it's going to be diminished. They're not going to be as rational and calm and controlled and understanding as if they were sober. But remember, it has to be from a recognised medical condition. So if this person is just drunk or just on drugs, then that is not a defence. It may, however, be a recognised medical condition if it is a sign of alcohol dependency syndrome. If the drinking stems from a recognised medical condition, then you may be able to use the defence of diminished responsibility. How do we know that in the exam? Well, you've got to be really careful. Lots of cases have made very, very clear that it is not just about being a heavy drinker. So if a person has just drunk lots or drunk for a long time, that doesn't necessarily suggest they have alcohol dependency syndrome. And I've just underlined the word dependency. Dependency is the idea that this person cannot function without alcohol, that they cannot go throughout their day without intoxicants. So we are looking for signs of dependency. Now, if they were drunk because they had a dependency, then they've acted because of a recognised medical condition. They can use the defence of diminished responsibility, as long as, of course, their abilities were substantially impaired. However, what if the two things are separate? A person is intoxicated, they are drunk, or they've taken drugs, and they happen to have an unrelated medical condition. So, for example, a person has depression, but they've also gone to the pub and drank lots. Or let's say a person has post-traumatic stress disorder and they've taken a lot of drugs that afternoon, not because of their PTSD, but because they wanted to. How do we handle that? Because the intoxication hasn't sprung from the medical condition like it has in the second rule. We refer to the case of Deichmann, and the Court of Appeal gave us a really important question to consider. State the question and then apply it. So the question is, would the defendant have killed because of their condition despite the intoxication? So we're almost looking at the situation and kind of trying to ignore the intoxication if we can. So for example, if a person is depressed and they happen to be drunk, if we sort of try and ignore the drink, do you think they still would have killed because of the depression? Or do you think if they'd been sober and depressed, they would have controlled themselves, for example, or understood their behaviour or made rational decisions? If that's the case, then we're trying to blame it on the alcohol, which we can't do. They can't use the defence. We have to be convinced that at the end of the day, intoxication aside, that their depression is what affected their mental functioning. So how do we conclude here? So if you've gone through and you believe that they were substantially impaired, they had an abnormality of mental functioning, if it was just due to alcohol, then there is no defence on diminished responsibility. If, however, we believe it was due to a recognised medical condition, something internal, depression, post-traumatic stress disorder, alcohol dependency syndrome, postnatal depression, epilepsy, things like that, then assuming all of the elements on the previous board are met, they can use the defence. And their sentence will be changed from mandatory life to whatever the judge thinks. And remember, that could still be life, just at their discretion. It may be more appropriate to give a hospital order, and you can suggest that in the exam. If you feel like the person's going to be a danger to the public, you may suggest a hospital order. If it's actually not about what happened and what was going on inside, if you actually think it was because of what someone else did, then you need to consider loss of control, which I'm going to go through in the second part of this summary video. So thanks for watching, and hopefully you click on the second part.